Court does call the case of Ping Shen versus Croy Ekafong, Steady Croy Ekafong, NFC.
This case comes in hot right from the start, and you're about to watch Judge Simpson navigate one of the messiest payment plan disputes this courtroom has seen. We've got two defendants, a shared judgment, a surprise garnishment, and a lawyer who thinks he can out-technical the judge. The tension is already baked into the facts. One side says the garnishment was wrongly continued, the other side insists the defendants misstated the facts, and Judge Simpson, known for his no-nonsense approach, is not about to let anyone twist the legal record. Before anything even begins, you can feel the storm forming. The numbers don't match, the timelines don't match, and the parties are clearly not on the same page. And that is exactly where this drama gets interesting. When payment plans collide, when garnishments overlap, and when the judge must untangle who owes what, when, and why. As you watch the opening moments, pay attention to how quickly this goes from a simple review hearing to a full legal showdown. Somebody is about to get corrected hard, and the judge is preparing to lay down the law with precision. Buckle in.
Right. State your names for the record.
Sade Caillou Ashampong.
Osei Ashampong.
Afternoon, Judge. Stuart J. McAfee happened to Ping Shen.
All right. And what are we doing on this case today?
Your Honor, you had scheduled this for just a review to be brought up to date, I imagine, on what
The payment plans, yes. So how is it going?
to date they've paid.
All right. And so how much is left owing on this?
$2,660.12.
So at $500 a month, it's going to be, oh, go ahead.
And I also have like an additional 500 monthly. When we had our case in our final judgment, I believe that was.
This is where the confusion cracks open. The defendant believes she's paying not just the agreed $500, but an additional $150 through a garnishment, meaning her total is way above the court-authorized plan. This is a classic example of how easily financial obligations explode when multiple orders overlap. The moment she mentions an extra $150 being taken every 2 weeks, you can literally see Judge Simpson's head shift into audit mode. Here's the key legal point. If the court orders an installment plan, active garnishments are not supposed to continue unless specifically authorized. That's why Judge Simpson immediately pauses and begins asking for clarity, because if both defendants are jointly responsible for the $500 total, then doubling payments through separate garnishments potentially creates an unlawful overcollection. The drama rises fast because the defendants think they're following the rules, yet their paychecks are being tapped twice. Viewers, this is where the legal stakes get real. Miscommunication can cost hundreds, even thousands. Question for you. Would you have caught the discrepancy early, or would you assume the garnishment was just part of it?
What she's saying is we were on the case together. So when we came to court the last time, you had dismissed my garnishment. My wife's garnishment didn't go through, so hers continued. When we put the paperwork in, he made it as another case. So she's still being garnished.
Well, it's $150, so I get paid.
It's additional to the 500 that we had already agreed to. So we're trying to figure out why and if we can stop that garnishment, because we're already splitting a payment of $250 because we're on the same case for $500.
So right now he gets 500, which was the case that was judgment, and then I pay an additional 150, so a total of 650.
Okay, so hold on a second, ma'am. You pay that additional 150.
Yep.
How?
$75 is taken out of my check every 2 weeks.
Got it. Mr. Mack, you know anything about that?
Yes, Your Honor, the defendants have actually misstated the facts. There are two being judged in that case, two judges.
The attorney steps in confidently, maybe too confidently, accusing the defendants of misstating facts. But watch how fast that confidence backfires. Judge Simpson immediately stops the defendant from interrupting, not because the defendant is wrong, but because the judge needs clean, uncontaminated testimony. This is how a seasoned judge keeps control. Eliminate crosstalk, keep the record clean, and force precision. Then comes the turning point. The attorney claims they did not agree to the $500 plan, but Judge Simpson already has the paperwork in front of him, and nothing embarrasses an attorney faster than a judge reading back their own signed agreement. When he cites the date, September 1st, 2023, you can feel the entire power dynamic shift. This is an important legal lesson. Courts rely on documentation, not memories. You can argue interpretations, but you can't argue what's written and signed. The judge knows it, the defendants know it, and now the attorney is being cornered by his own filings. Audience question: do you think the attorney genuinely forgot the order, or was he hoping the judge wouldn't look it up?
So they are equally liable. So Mr. Akumengapong,
Hold on, no. So how,
Because we're on the same case, sir.
sir, I didn't ask you to state anything to me. So, Mr. Mack, these parties agreed they were gonna pay $500 a month.
no,
That-
no, they did not.
Oh, I'm looking at it right now. I'm looking at it on September 1st of 2023. You were present in my court.
Yes,
Defendants to pay $500 per month.
defendant.
Defendants.
Okay, and so what I'm saying is the judgment against Mr. Akumengapong was ordered by you at $500 a month. At the time, there was no garnishment against Mrs. Akumengapong. That's why we sued them both individually and severally.
So hold it, when did the garnishment happen?
The garnishment happened through the Ypsilanti schools. The garnishment was.
No, when was that ordered? When did you request a garnishment?
That was ordered assigned by this court.
Where's Ann?
Okay, first of all, Your Honor, with all due respect to the court ordered me to prepare an order of garnishment concerning this here argument. And the order clearly states, as of September 15, 2023, and no later than the 15th of succeeding months, the defendant also Akumengapong is to tender $500 per month of plaintiff. And then, so,
All right. No. Mac, no. You can play those technicalities all you want with me, but here's the reality of it. The motion and affidavit for installment payment plans was filed in both of these defendants' names. Out of that motion for payment plan, I suspended garnishments because I would have to do that when I order the payment plan.
Okay.
If the order is incorrect, then I'm vacating that order.
I've got them both right here.
This is Judge Simpson at full strength. When a judge says, you can play those technicalities all you want, that's judicial language for, stop trying to outsmart the bench. The attorney attempts to argue the structure of the garnishment order, but the judge shifts the focus back to the core legal truth. Once he suspended garnishments under the installment plan, it became illegal to continue taking money from either defendant. What makes this moment powerful is the judge's absolute clarity. He isn't guessing. He isn't interpreting. He is holding the attorney accountable to the court's own written orders. The presence of both defendant names on the installment motion is the nail in the coffin, meaning the attorney cannot justify continuing garnishment against the wife while invoking the old judgment structure. This is courtroom reality at its finest. Legal technicalities crumble when confronted by judicial authority and procedural facts. And the defendants, who walked in frustrated and confused, are suddenly watching the judge dismantle the opposing counsel's entire argument piece by piece. This is what courtroom viewers love. The exact moment when fairness overrides clever maneuvering.
Both what?
Separate names, separate garnishments. Both right here. Right here.
Show them this. Their motion and affidavit for payment plans. At the top, both names. It is in fact, once I ordered it, illegal for you to garnish either one of their checks when I've suspended it.
I'm going by what the court has ordered for garnishment. You asked me a question.
Okay, if you're saying, give me that file back. And Mr. Mack, we're gonna make it right. Today. All garnishments are hereby ordered suspended. As to both defendants. Defendants, plural, shall pay $500 per month as previously ordered.
Your Honor, there's something else I'd like to bring to the court's attention. Your colleague, Judge Barr, issued an order stating that Mrs. Angamendapong would pay $150 a month. I don't know if that's
Vacated. That's not what was ordered on this case. If you want to bring that up before Judge Barr and he wants to discuss it with me as to which order will hold, you can. But I will tell you in this case that these funds are coming from, it is $500 per month. As I've indicated, any garnishment that has been issued is hereby ordered by this court suspended. Counsel for the plaintiff will prepare that order and have it on my desk by Monday morning. Thank you.
This is the judgment swing the defendants have been waiting for. Judge Simpson's ruling is crystal clear. All garnishments stop immediately, and both defendants are responsible only for one unified payment of $500. That's it. No hidden add-ons, no duplicate orders, no paycheck bleeding because of clerical confusion. But the tension doesn't end there. Notice how the attorney suddenly shifts from arguing technicalities to asking about mailing procedures and fairness. When the judge calls him out, now you want to be fair to them? That's a professional sting delivered politely but sharply. The judge sees the timing, sees the strategy, and refuses to let administrative excuses overshadow the legal correction already made. What's brilliant is how Judge Simpson redirects the entire process. Instead of mailing chaos or disputed drop-off locations, payments now go directly into court escrow. No middleman, no excuses, no manipulation. This is a masterclass in judicial control. Eliminate the confusion, centralize the process, and protect the defendants from unnecessary financial strain. Audience question: do you think the attorney was genuinely trying to help at the end, or just trying to save face after losing the argument?
Thank you.
Will the date of the 15th,
Are we finished?
will the date of the 15th that you had ordered and the
Date of the 15th of what? The payments? There'd be a payment 15th of each month, as it's previously ordered, but only $500.
okay, as to both of them combined. So, and I want to get this clear, and there's nothing.
I think I'm very clear.
Okay, well,
These two will pay $500 per month, Mr. Mack. That's it.
okay,
There'll be no other garnishments of any personal wages or anything along those lines. Those are all suspended. You will prepare an order to that effect, my desk, Monday morning.
all I'm talking about is the mailing of it because of the issue. Okay, so these folks, they paid $14 to have some kind of expedited mailing, and they keep doing that. But I'm saying, as an officer of the court, and in fairness to them,
Well, what? You now want to be fair to them?
well,
Seriously?
Judge,
He set up an agreement where we could drop something off.
Well-
He told us that we could not drop it off at his office and that he designated a specific place
yes,
and someone else to give it to. So therefore and it was only once where I did certified mail for on the 15th to be
Yes.
sent to him.
yes, and they can keep doing that. They can well keep doing that.
It costs more money to do that. The reason that we said we could drop it off on the 15th
Oh.
is because we don't get it until the 15th.
Yeah.
So we wanted to drop the money orders off as soon as we get them. But he's not allowing us to do that.
Well, it isn't that, it's just about dropping it off. But you
Well,
know,
he
Judge,
instructed us.
No, here's what we're gonna do. Your $500 per month, you need to have it in cash. Defendants to pay monthly payments on the 15th of each month into court escrow.
Okay.
So you just bring it here, the $500. I don't know what their problem with taking your money. We'll be more than happy to take your money.
Thank you.
That's fine. All this is done for their convenience, that's fine.
I'm done, Mr. Mack. Have a good weekend.
Thank you, sir.
Same to you.
Court calls case Group 5 Management versus Roderick Smith.
Hopefully you're in a better mood now. I'm here.
You know, okay. I am seeing Mr. Smith. I'm in a better mood. All right. I'm doing well. Where are we on this case?
This case closes with a decisive, clean ruling from Judge Simpson, exactly what was needed to resolve months of confusion. The judge confirmed that the original installment plan applied to both defendants jointly, meaning they owe $500 total per month, not separate amounts. He suspended all garnishments immediately, preventing any further wage deductions until the payment structure is completed. He also directed that all future payments go straight into court escrow, eliminating miscommunication and ensuring transparency. This ruling not only protects the defendants from excessive financial withdrawal, but also reinforces the court's authority over how judgments must be administered. The attorney was instructed to finalize the corrective order by Monday morning, solidifying the new arrangement. This case demonstrates why judicial oversight is vital. Without today's clarification, the defendants could have continued overpaying indefinitely. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.